Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. Getting divorced is hard. But getting divorced with a child with a disability would be even harder. So today we're covering getting divorced, going through property settlement and children's orders with a child with a disability. Today we're going to cover all of the questions that we've had been sent through and also things that you might be trying to figure out yourself. Asking the amazing Lynn Galvin, my mum, who has been in the court and doing legal things for a very long time. Welcome, Mum.
Thank you, Laura. Hello, everyone.
Now, before we start, just a disclaimer, we understand that the correct terminology is person with a disability. Hopefully, we'll use the correct terminology the whole way through. And if we upset anyone by accidentally using the wrong terminology, we're sorry. We're not medical professionals, but we will use Mum's legal expertise to hopefully help you. And also, this is general advice only. Everybody's situation is different, isn't it, Mum?
Absolutely.
Yes.
Just like every child is.
Yes. So, Mum, how many cases do you think, percentage-wise, have an element of a child with a disability or an adult child with a disability that you come across?
Well, from personal experience, I have to say that it's at least 1 in 2 where the child has been diagnosed with some mild developmental disability or going up to a much stronger one. And I don't know if it's because we're just better at recognising it now or if those children with those developmental difficulties have parents who find themselves getting divorced more often than if the children didn't have disabilities. I don't know the science behind that or the social science behind that, but I'm coming across it a lot. And the courts are getting better at looking at it.
So I guess the mental load of looking after a child with a disability on top of looking after your relationship, I guess it is a little bit more of a strain, and it is going to make relationships a little bit more trickier from time to time. So I guess maybe.
Well, so it makes court trickier too because you're doing documents, you need to find downtime, and sometimes you can't if you want to talk to your lawyer and you've got sort of your hands full.
So let's get into some of the main questions, and that is, how does a court recognise a child with a disability? How do you have to present that to the court so they know?
So it's not really enough just to say it. Even if both of you say it, it's still, the court can't really rely on that. So you need an assessment of the child. I wouldn't suggest taking them for a fresh assessment, but if you think your child has a condition, I dare say you've had some correspondence about it, even from your GP or you've been to a specialist or something. And at the school, if they're at school age, there's probably an assessment being undertaken there and they might have extra assistance. So you do need to produce some evidence. What mostly happens is, in my experience, is that one person says the children have a condition. The other parent says, well, they're perfect at my place, they don't. And so the court can't get involved in that. Just like we're not psychologists or psychiatrists, neither is the court. So then you need that independent evidence.
So you need the evidence to say, my child has this.
Special needs, yep.
Because potentially the other parent might say, no, they don't. But what difference does it make in the court's eyes if you do have a child with a disability as to not having a child with a disability?
Okay. Well, there are characteristics of various conditions. It can be either a general thing, like a child doesn't handle change very well or can only sleep in the bed that is modified for them or something like that. But there's also kind of general recognition of the needs of children.
So that gets me into that. Does it affect the chances of the standard 50-50 assumption that they'll spend 50% of the time with one parent, 50% of the time with the other parent if their child is with a disability?
Look, sometimes it is, sometimes it isn't. Sometimes the load, a loving load, but it's hard work, needs to be divided between the parents, and it needs both parents to step up and give each one a little bit of a break, but boy, do they need to coordinate very well with each other so that there's a consistent level of care. So it's just like there's no one child the same. there's no really one blanket set of orders, but mostly I'm seeing the parents trying to work together just to cope. But if you've got one person who says there's no disability, you are really pushing for a hard time. And the thing is, of course, if a child masks their discomfort when they're at one house, they'll come back and then they'll let everything goes to pot because they're back in their own environment. So, yes, it's a tricky thing. So I think independent evidence is the best way. And then sometimes the court can take notice of maybe published papers about general characteristics of people with that disability, children with that disability. I think there's a thing called judicial notice where something is such common knowledge that the court can just say, oh, yes, everybody knows that. And one of the things I think is becoming common knowledge is that children don't like change. If they've got any sensory or developmental or neurological conditions, you have to go very slowly and gently into any change.
So that's when step orders would happen, where there's like the orders step them into the situation. And
they'd be much slower than a progressive step, say, with a child who was little or hadn't seen a parent for a long time. You do progressive orders there where it might start off with 2 hours on a Saturday and then after a few weeks it becomes 2 hours Saturday and Sunday. Well, for a child with a very severe disability, that might be far too fast and you might have to make them even slower.
Okay. All right. What happens when you said the other parent potentially could be saying they don't have a disability? What happens then? Is that something that the court takes into consideration if you prove that they do, but the other parent isn't looking after that side of things?
Well, remembering that the courts the main imprimatur for the court, the main ambition of the court is the best interests of the child. If you have demonstrated by use of third-party proof, reports, that a child has a disability and you have another parent who's in denial about that, particularly if there's medication to be provided or therapy to be provided, then the court is going to err on the side of leaving the child with the parent who gets it. Really, basically, if the other side doesn't get it, well, they would try and make orders, I guess, that would still allow a child to have a relationship with the other parent, but not to the child's detriment, so that they don't miss any of their therapy, so that they're not in an environment that's not conducive to their development and best interests.
Well, that's good news for anyone who's out there who potentially has that situation going on. If you do end up in court, that's, you will be looked at. There are a lot of people, though, and we had people who've written in who haven't left the situation. They haven't left the home and they haven't left their partner who they want to be their ex-partner because they're afraid that they don't know that they can support the child without the additional income and support of the other parent.
Yes.
And I guess that moves us into property. What happens there, Mum? So if there's someone right now listening at home who's not leaving their ex or not leaving their partner because they have to stay because their kids need the extra support, what kind of things can they look at that could potentially give them a way out?
Yeah. Okay. So it depends on the sort of person the other parent is. It sounds like if you're in that situation, you are getting some physical support and emotional support from the partner, even if you want him to be or her to be your ex. So I would think about going to mediation before you separate to talk about how you might manage the children. And it might be that a week is too long for any one person. And I do have matters where children swap every couple of days, and that gives the other person time to catch up on sleep and so forth. It has to be done carefully within the confines, I guess, of what the child can cope with, but you can work it out. If there's two of you together, both with the child's best interests, then, hopefully that trumps any bitterness with the separation.
What about financial?
Financial, you are eligible usually to ask for more support. You can tell child support that you have additional needs with the child, and either if you haven't been able to work it out in a child support agreement with your ex-partner, the agency may review and increase your child support. That would require you to produce your receipts and letters from various professionals. I also like my clients to produce a calendar both for negotiating time with children and also so the agency can see how it impacts on you. And also in property settlement, which I suppose you're going to ask next, having an adult child or even a person that you have to support and can stop you being able to work full time. And that definitely is one of the factors in that the court looks at under Section 75(2), whether you've got the control of a child, care and control of a child under 18, and then beyond that into adulthood, if you've got a legal responsibility to support someone.
Okay, so the court, if you end up going to court, the court can make an order that helps support you financially by giving you a bigger outcome.
Bigger share of the property.
Bigger share of the property. What about spousal maintenance?
Yes. If you're unable to work because of the child, it shouldn't be conflated. The issues shouldn't be joined together. That's a child support issue, and it may mean that if you can't get enough money through the child support agency, you go to the review process, you go to the what was the Administrative Appeals Tribunal and has now been demolished, but something else will come in, and ultimately probably to the court if you really can't make ends meet. But spousal maintenance on the grounds that you've got the care of children isn't as strong a ground as it used to be because there's daycare now and all of that. But so I think you need to be clear what money is for the child and as a result of you having the child in your care, and what money is as a result of you not being able to work. So I think it's just a cracker like that. You would raise that issue and say, I don't see myself being able to work full time, if that's your situation for years. And the percentage adjustment to you on a property pool, and there's always a component, Section 75(2), is that lump sum maintenance component for you, spousal maintenance, would have to be much, much bigger.
And, of course, we talk about that, how to figure that out in our course, the DIY Divorce Blueprint, where we talk about the different percentages. True. And so that if you're interested in that, you can check that out on www.thedivorcecourse.com.au and go to our online courses. So basically, Mum, before you can go to court, you have to go to mediation pretty much these days with kids, right? Yes. And that's definitely solid now.
Yes.
So what kind of evidence can the other parent gather to provide to the mediator and to the other parent to show, look how much money this costs, look how much time this takes. Even I think for, that's like severely children with severe disability, physical disability, where they need a full-time carer, as well as, a child with autism on the one end of the spectrum, my daughter has autism, as you know, but she can look after herself, so it's a lesser extent, but still having to do certain things and pay for certain things. So what kind of evidence can that person who's listening today with the child with the disability to present to the other side at mediation and eventually at court if there's no agreement to show?
Yeah. Okay. So in terms of to show your expenses, I think you need to get letters from each of the specialists that they see, each of the helping professionals that they see, setting out the frequency of the visits. Again, that calendar is really handy, and you can really, it'll frighten you because I've done it with people before and they are gobsmacked at the actual cost. But, find out what it costs you a month and multiply that by 12. Consider any special clothing, the fact that you might have to drive the child to school rather than let them catch public transport, and all of those other things. So it's receipts, it's schedules for the future, receipts for the past, credit card account showing your payments.
I guess you could
even while you're together. Yep.
Look at time, how much time is spent.
Yes, that's right.
Yeah.
And the first thing, though, is to get the other party on board with the diagnosis. And to do that, you would produce some sort of report from a specialist. But if you've got a particularly tricky partner, they may not believe that specialist. And that I would say, the best thing then to do to give your mediation the absolute best chance of settling this issue between you both in consent orders or a binding child support agreement would be to get your partner to give you a panel of 3 independent people who can make an assessment, and you choose one and get the child assessed by someone that your doubting ex can't dismiss. Okay, so you've got to get that solid ground. Is there a disability? To what extent does it impact on you, your life? To what extent does it impact on your dollars? Yeah.
And I know it sounds very crass that we're talking about this because we love our children and, you know, it's
whatever
it's
it
nothing.
takes.
We don't care, you know, like it's nothing, but it's all about, and I think a lot of our listeners who do have children with disability need to remember putting a dollar amount, putting a time amount may feel crass, may feel broke, like, because of course you would do whatever, but you need to do that for the sake of your child, to do the best case scenario for the outcome moving forward for their future, so that you can be there and you can continue to do what it is that you were doing.
Because if the difference, you're not really doing this for you, of course. You're doing it for the child. And if you don't do it, then your child has only the resources you can provide or that are ordinarily provided to a child without a disability, and also your time may be limited. And if you're suffering and struggling, your cup isn't as full as it would otherwise be, and, you know, how can you then give to the child? So it's a more subtle thing as well in your emotional ability to cope with the child. I mean, you know, it's interesting in my experience when parents have a severely disabled child.
Child with disability.
I beg your pardon, yes. Child with disability, with a severe disability. They are more likely to work things out because they've both been there and they understand. It's these more subtle signs, or where one party's in denial, that you do have your problems.
When it comes to dealing with medical professionals, what are the rules?
You've made it this far. You've separated or made the decision, and that's a big deal, and that takes courage, and we totally respect that. The problem now is you don't know what the next step is to do. You might have some idea, but you're worried it might be costly or you might make a mistake. We don't all have a lawyer on speed dial to ask those little questions swirling through our minds or to fully explain the process in plain speak. If this is you, you've come to the right place. This course was created because I wish I'd known what I do now. Lynn knows the law, and we both know what it is like getting divorced. It was during my divorce that she realised how much more support and information is needed for people going through this process. Knowledge is power. We're all capable of learning and doing things to help us to get to a better life. Mum and I want to give this knowledge and know-how to you and save you money while we're at it. Empower, educate and equip yourself with the legal know-how and the tools you need to get your divorce, property settlement and children's matters finally settled. Work through the course at your own pace without feeling confused, lost, scared or overwhelmed with family law legal jargon and processes. If you're ready, join us at www.thedivorcecourse.com.au and click on Find Out More about the DIY Divorce Blueprint.
When it comes to dealing with medical professionals, what are the rules?
It's, you mean in terms of parental responsibility?
Yeah, well, are you allowed to go to see a doctor without the permission of the other parent? Like, are you allowed to get a diagnosis?
So there are three sorts of parental responsibility. The one that you have before you leave and before there are any court orders is called joint parental responsibility. And each of you can do anything on your own for the child without informing the other, just like if you were in a happy relationship and still together and little Mary needed to go to the doctor, whoever was off that day would probably take Mary to the doctor. That's your normal, that's how everyone is until the court interferes with that by making a different order. And the court most frequently makes an order for what they call equal shared parental responsibility. Okay. ESPR, people call it, equal shared parental responsibility. And that means that neither of you can make all of the decisions about the child alone, that on every issue, except like what toothpaste to use or the day-to-day things, but every medical issue, for instance, needs to be made jointly in a consultation, and you need to both agree, and then that's the path you take for your child. And that's the legislation's preferred option, is that both parties have an input in caring for their children and making decisions. However, sometimes equal shared parental responsibility doesn't work. If their parents have a difficulty communicating and coordinating. It has to be a significant difficulty. The court years and years ago used to say, well, if you've had to come to court, you don't have the capacity to cooperate in parenting. But that's a very old-fashioned view, and the court really, it's only in exceptional circumstances that the court will go, oh, this parenting relationship is damaging to the child for their interests or her or his interests. We need to give one or other parent sole parental responsibility. Which is a big deal because sometimes they'll give a parent sole parental responsibility with a requirement that they coordinate and inform and discuss with the other person, consider the other parent's views, and then if they make a decision contrary to the other person's views, the other parent, give them an explanation of why they have. But they still get the final say-so. And, gee, this came up a lot during the vaccinations in COVID and so forth. And then the final sort, which our listeners should know, I need you to know, it's very rare, is sole parental responsibility, where the court gives all of the power, so to speak, over the child to one parent, and the other parent only has responsibility for the child during the time that they are in their care, and then only for day-to-day things like what are they having for breakfast and are we going to go to the beach today, that sort of thing.
So in answer to my question, can you take your child to get a medical report or something like that? The answer is
it depends where you are. Whether you're still in the joint parental responsibility stage, or if the court has made an equal shared parental responsibility order, or if the court has made a sole parental responsibility.
And if you're not in court at all,
then it's joint and you can do it.
Yeah. Okay. All right.
But be careful.
Yes.
If you do stuff that ultimately, if you're not bringing your ex-partner along with you, I don't mean physically, but if they aren't on the journey of discovering and getting the diagnosis, they will be suspicious and say he's just done that, so I can't see the child as often.
So it's important, I guess, to always keep in touch with that other parent, you know, and let them know when you're going, what you're doing, and negotiate, talk about, discuss. Look, and then we have talked about in other episodes, if you want to listen, about coercive control and other situations where some of our listeners who have written in about this particular topic have been stuck. So go and listen to those as well. But when it comes to the NDIS, Mum, because that is a big issue, I guess, for any parent with a child with a disability, how is the National Disability Scheme considered within the court system when it comes to property and child support and things like that?
So the NDIS money is coming from the Commonwealth Government. It's important to remember that the family court is Commonwealth Government as well.
Okay.
Except Western Australia.
So they all live in the same house. That's how I started thinking about all those things.
Yeah, maybe. I think they all have the same purse.
They've got the same budget.
Public purse.
Yeah.
Yes. But they also, like people who live in the same house, have a similar agenda that the children should be advantaged, not disadvantaged. So I've yet to see the court say, well, the mother won't need that much because she's got NDIS funding for the child.
Right.
Or the father doesn't need that much because he's applied for NDIS and he'll get it for the child. The court just takes it into account. They may, in a small way, I think, recognise the benefit of NDIS to the child, and that may reduce somewhat the need for you as the person with the child in their care to have a big lump sum, you know. So it's just one of the factors that they take into account.
Okay. So that's something you should take along with you if you do have a National Disability Scheme, the information, what the payments are.
Yeah.
Take that along to mediation.
Yes, I think so. I think I've seen the courts, people do it, right? They do the NDIS and the court, and they say, oh, she won't need it or he won't need it. They've got NDIS. The court just kind of glosses over that. In my experience, I've not seen a decision that is different because there's NDIS available or not.
So do they split the NDIS up payments between them, or is it just whoever's taking the child to do the thing that just pays for it.
My understanding is there will be a pool of money available for the child.
Yes.
I think the parties really need to agree what things the child does, and then you submit the account. That's my very poor understanding of it. And so you need to tell them everything about how the arrangement is, and you both need to be on board with the processes.
Wow. Okay.
It's tricky.
And yes.
Can I just mention one other thing with NDIS?
Yes.
I understand that you can't apply for it after the age of 65, but I have had cases where the parents are eligible for NDIS through some disability and that also really isn't getting much airtime as far as I can see in the courts with she doesn't need much because they've got NDIS funding.
Oh, okay.
But, of course, the court does make adjustments in property settlement if a person can't work.
Yes.
So, it's all...
And look, and we definitely need to do an episode on parents with disability.
Yes.
And how that affects orders and the court system, but that's a whole nother kettle of fish.
It is.
That we will touch on at a later date. Adult children with disability, how that may affect the outcome of your property case as well. How the court recognises it. Basically, you just have to say, here's some
proof. This is what I say, and here's the proof.
And that's what it always comes down to.
It's always that.
But I think it's important to point out to anybody who is listening, who hasn't gone through the stages yet of separating or is going through the stages, going to court is a long, drawn-out process. It's not supposed to be, and maybe the new changes will make it that way.
I'm a little bit hopeful.
Mum is hopeful. But you have a chance in the beginning, before you go to court, to do that mediation and to negotiate your little butts off.
Yeah.
For the betterment of everybody, to not end up in the court system. And if you have a child with a disability, you're not only going through an emotional turmoil of breaking up, but you're also still having to keep it together more so than maybe other parents.
And the children will also be acting out usually and going through a trauma of their own. Yes. So it's superhuman time.
Well, that's what that child impact statement is. Yes. So can you tell them what that is all about?
If the matter goes to court, there's a couple of projects that the court's working on now to identify at-risk children through violence, or if there is a risk to them in some other way, and I do think the disability would be eligible for that. And very early on, the court counsellors, they used to be counsellors, and then they were report writers. Now they can do a child impact statement to the court to give everyone an understanding of what's happening with the child. It's not a full family report, but they're just focusing everyone's mind on what is this doing to your child, as if the children don't have enough to worry about and to cope with. What are you doing to your child? And it's hoped that those early refocusing of everyone's views, and also, can I say, I really applaud the introduction for rules that don't allow an affidavit unless you're asking interim orders, because those affidavits, once it's in writing, once it's signed, once it's given to the other side, really damages the relationship between the parties, and they really can't work well. And years ago, there was no requirement for an affidavit, and there were a lot of things unsaid, but, a lot of things that probably didn't need to be said. Yeah. And so we were able to, I think we sorted more things out. But once that's written and line in the sand, then people feel they've got to respond. So I think the court is working pretty hard with its pre-action procedures, compulsory mediation, and the intervention of that child impact statement person. And they get involved in the court mediations as well.
It's really just to try and keep you out of court. But I guess...
Or settle early.
And again, as we've always said, Mum, if you've always said, there's always, you end up in court mostly because one person's unreasonable.
And that wasn't my saying, that was Judge Barry. Yeah.
So in the end, don't beat up on yourself if you end up having to keep going for the sake of the children, for the outcome, etc. Don't beat yourself up. But if you feel like there's something that could give so that you could settle, so you don't end up going to court, then definitely. But what I'm trying to point out, I think, was that having a child with a disability, having all the changes occurring, moving houses, and the stress that you may be under for court appearances or writing documents, really think hard about that before you say no to an offer that is very close to what it is that you wanted.
I think you should choose your lawyer fairly carefully too. People have different, just like any human being. I suppose lawyers are still human beings, but lawyers have different. As I'm speaking as one, but lawyers have different approaches, and there are those who will tell you when you ring them up if you're trying to find a lawyer how they're going to win for you, and they're going to just demolish the other party. And I don't think you need that.
No.
The court doesn't want that.
No.
What they want is someone who can try and find some middle ground.
Yes. So are there any lawyers out there that are specialists in the disability field? Or is it?
In family law, no. I think like I said, it comes up so often that we all become...
Well, in saying that, family law specialists.
Yes. So we're family law specialists, but... So the only people who are really educated lawyers about who really understand the NDIS and disability, I guess, are people who work in the lawyers who work in the medical field or who work in that legal medico area where they help with those things.
But you don't need that really.
No, well, the judges don't have that training. We all get a little bit of training and we read the cases, and the judges are gradually they're educated by the litigants really and their lawyers who refer them to published papers and also just their lived experience. So you need to show them how your day is. And even though it seems like a bit of a pity party and you might feel very terrible after writing it down, I do think that you should take the trouble to do it, because if a judge reads that, it will tug at their heartstrings. They do have hearts, and that will help in your case.
So make sure you've got
weekly and your yearly, like, do you ever get to go on holidays? What does it mean? Can you go to your book club at night or not?
So putting a little brief summary for your lawyer and a little brief day-to-day list of what it is that you do so that they understand the impact, so that if you do move forward in negotiations, they can go into bat for you better. Yeah. And also if you do end up in court and you have to write an affidavit, they know what you're going through. And I'm sure that there's a lot of support in the different disability groups out there.
There are.
I'm sure you could go and find some information for each type of disability and how that is used in the family court, how that is looked at and described or explained.
And if you've got friends in that community, ask them if they've found a lawyer who was empathetic.
Yes.
For some time when I was still practicing, I had a series of people from one organisation. Yes, I know, but I'm trying to
semi-retired practicing, but yes.
But I had a series of people with autism, and they were being referred by each other.
Right.
Because once they find a lawyer that gets it.
Yes.
I'm not sure I actually got it in those days, but, we were all just learning.
Yes. So I think maybe put your feelers out, ask around who's a good lawyer, who's been understanding, respectful, and has been your support, to get you through that.
If I ever did a PhD, I think it would be on the impact of that, disabled children and family law proceedings.
Okay. All right. Thank you, Mum, for all of that information. And to anybody out there who's going through that, we're here for you. You can listen to an additional podcast that we have on, property orders, children's orders, you name it. It's up there. Have a look for it. And of course, in the future, if you've got any other topic ideas, send us a thing. And we are going to be doing a webinar very soon, Mum.
We are. Yes.
So if you'd like to come along to the webinar, go to www.thedivorcecourse.com.au and click on webinar. And then you can grab your seat, and we will see you there. And you can, at the end of the webinar, there's a Q&A where you can ask Mum your questions. So if you've got any questions from today's episode, you can come along to that as well. All right. Thanks, Mum.
Thank you, Laura. Bye, everyone.
Bye.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.